Hi, this is Lisa Cukier from Burns & Levinson, and I'm here with my law partner, Tiffany Bentley, and we are delighted to bring a webinar to you regarding divorcing when you have trust interests. It's a very tricky issue, and we're going to talk a lot about it and try to delve in so that you can leave this webinar with a better understanding. We're with Burns & Levinson. It's an office in Boston. We have satellite offices in Wellesley, Andover, Hingham. We have a significant office in Providence, Rhode Island as well, and a few other offices as well. We bring this webinar to you for the Divorce Law Monitor. We do webinars periodically, and we're delighted to have you join us. Afterwards, if you have any questions, just reach out to me or my law partner, Tiffany Bentley. And without any further delay, I'm going to hand it right over to Tiffany Bentley.
Thanks, Lisa. I'm Tiffany Bentley. I'm a partner in the private client group at Burns & Levinson, along with Lisa. She and I have very similar practices, actually, that span both domestic relations law and trust and estate law and litigation, which really gives us what we hope is a helpful perspective on how those two worlds intersect, and in an area of law that's been developing quite a bit over the past few years as to how trust interests are treated in divorce. We'd like to go a little bit broader than that and also talk about other ways that gifted and inherited assets may impact a divorce. And before we jump into that, I do just want to mention there are the Q&A and chat functions are available in this Zoom. So if you have a question or if you have something that you'd like us to address, feel free to use those functions and we will try to address them. If we don't have time to address questions during this webinar itself, we will reach out afterwards and follow up and be happy to continue the conversation. So with that being said, there are really two broad ways that inheritance and trust matters can come into play in divorce. And for the predominance of this webinar, we will focus on asset division concepts. But I did want to sort of mention briefly at the outset the other way that these issues can come into play in a divorce, and that's with respect to child support and alimony. The child support guidelines in Massachusetts do specifically include distributions and income from trusts in the definition of income that can be considered when calculating child support. And the alimony statute incorporates the definition contained within the child support guidelines, though it goes on to make a specific exclusion for capital gains or dividend and interest income that is generated from assets that are divided under Section 34 of the divorce statute. So to the extent that a trust interest is included in the marital estate and is divided among the spouses or allocated pursuant to Section 34, then there would be an argument for whichever spouse is retaining that beneficial interest or that trust interest to exclude the passive income from a child support, from an alimony calculation. So that really does bring us to the critical part of this webinar, which is what trust interests are included under Section 34, what is part of the marital estate, how can it be taken into account? And that will give us a good segue into Lisa's first topic here.
Thank you, Tiffany. So, at the bottom line, people who are going through divorce and also people who are doing estate planning come to us and they ask, is my family trust protected? I mean, that's really the bottom line here. Is my wealth protected, or is it going to get chopped up and decimated in this upcoming divorce? Or when people are doing estate planning for their children, their adult children, and they're thinking about leaving assets for children, they want to know, if I leave assets for my kids and my kids get divorced, is the trust going to get busted up? I mean, it's a really basic and important question that people ask, whether we're doing estate plan, whether we're handling trust litigation, or whether we're handling a divorce or thinking about prenuptial planning, any of that. So the thing that matters the most here is what's called the Section 34 factors, and that's something that Tiffany mentioned. There's a statute in Massachusetts. It's in our divorce laws, and it was developed after centuries of case law on divorce. And the statute determines how a marital estate gets divided. And the first question, of course, is what is part of the marital estate? It is anything that you come into the marriage with. It's anything that you acquired during the marriage. And it's anything you have at the time of divorce, and maybe even those things that you have even after separated, but before the divorce is final. That could be a lot of stuff. If you have a prenuptial agreement, that's separate. That might separate the assets. So take that out of your thinking. And this also, you're going to be thinking, this is why maybe we need a prenup. And yeah, we can talk about that too later on. But keep in mind that Section 34 of Chapter 208 says that the court can assign to either party in any percentage that the court deems appropriate any of the marital estate, no matter what it is, whether it's real estate, investments, non-vested rights, vested rights, anything accrued during the marriage, things accrued before the marriage, retirement, anything, boats, wine collections, cash, debt, anything. And it all turns on many factors that the court will consider. So the court considers to a great extent the length of the marriage. So a marriage that lasts 1 year is going to have a different outcome than a marriage of 30 years. The court's going to consider conduct. If parties have contributed to the marriage and they have worked hard and they made the home a beautiful home and they've raised children and they've worked hard in a business and they have really put their blood, sweat, and tears into the fabric of the marriage, the contribution, or they put cash assets into it. These are things that the courts will consider when dividing assets. The courts are also going to consider your health, your spouse's health, your age, your spouse's age, your occupations, if any, your station in life, the opportunities that you have to acquire wealth in the future. So perhaps you each are going to, or one of you is going to inherit assets, or perhaps you have received gifts during the marriage. This factors into, or you may be anticipated to receive gifts or inheritance after the marriage, or receive trust distributions. And this is what factors into the Section 34 criteria that the court uses to determine whether and to what extent a trust is going to be on the chopping block, if you will, whether it is vulnerable to be divided in divorce. And there are techniques that we use, which we're going to talk about, but there's techniques that we use that will immunize your trust from attack during divorce, but the law is shifting. So I want to really turn into focus on gifted and inherited assets and have Tiffany describe those very important issues.
Thanks, Lisa. So when we are talking about gifts and inheritances, we're really talking about two broad categories. One is interests and trusts, which we're going to go into in great extent for the remainder of the webinar. But I also want to talk about what gifts or inheritances might be received outside of trust during the marriage. So a spouse's parent dies and they inherit X dollars, or they inherit a piece of real estate and this becomes theirs outside of a trust. What happens to that property? So without question, assets like that are part of the marital estate in the broad way that Massachusetts defines the marital estate. The answer would be different in other jurisdictions. There are some other jurisdictions that presumptively exclude gifted or inherited assets from the marital estate that would be subject to division. But in Massachusetts, it's certainly part of the pot, but that doesn't necessarily mean that those gifted or inherited assets will be divided 50-50 between the two spouses. And that's really where the Section 34 factors come in. And where I tend to focus when I'm making an analysis or an argument on this type of issue would be on the contribution factor. Whether, when, and how the spouses contributed to the acquisition of these assets. And if it's coming from one spouse's family to the exclusion of the other spouse's contribution, I think that that's a factor. What also is so critically important is how the spouses treated the inherited or gifted asset during the marriage after it was received. Was it segregated in a separate account and never touched? Or was it deposited into a joint account and interwoven into the fabric of the marriage, which really would cause it to lose its characteristic as a separately gifted asset? The argument would be stronger for the beneficiary spouse to hold more of an inherited account that had been held separate from the marriage, that the parties hadn't relied on, that they hadn't accessed, that they hadn't taken regular distributions from, as opposed to the opposite. One particular case where we see this happen all the time is when one spouse's parents have contributed, gifted money for them to use for the down payment on a house. And almost 100% of the time, it is characterized as a gift on the paper because the spouses are also at the same time trying to qualify for financing for their mortgage to pay the remainder of the purchase price for the home. And for financing purposes, you can't be showing this additional loan coming from a family member. It's going to hurt your financing ability. All of a sudden down the road, a divorce is happening, and those parents say, they come back and say, we always intended to be paid back, and this was always a loan, not a gift. And people try to make those arguments all the time. I think really with some limited success, once you've got money that's been gifted in, it's been converted into a joint asset, and there's no kind of paper to back up the idea that it's a loan to be repaid. But again, something to consider when you're arguing about the contribution factor and where the marital assets derived from. So with that said, I think that we are ready to transition to a more focused discussion of trusts and how trust assets are in divorce. And to get us ready for that discussion, Lisa and I are going to just briefly define for you some of the relevant terms. So Lisa.
Thank you. So one way to protect your trust, and estate planners have been saying this for years and years, is to build a clause into the trust that's called a spendthrift clause. A spendthrift clause is a provision in the trust that says that the trust will not be available to satisfy judgments. And in plain English, what that means is that the assets, the trust fund, the assets in the trust can't be used to pay any, to satisfy and pay any judgments against a person that might happen because of any court process. That includes divorce, it includes contract claims, it includes personal injuries. And there's a case on point that relates to both personal injury and divorce that I just want to mention because that's going to drive the point home for you. It's a really interesting case, real human interest. So I figure this is a good one to use. It's the Calhoun versus Rollins case. This case was decided in 2018. Brian and Susan were married in 1987 and they divorced in 2005. But before they divorced, back in 2001, Brian had a severe car accident. He was driving, he was speeding, extraordinarily speeding, and he ended up in an accident and had a severe brain injury. It was so bad, and he caused himself such a brain injury that he needed a guardian. He needed somebody to manage money for him. The couple had money. They had some assets there. And Susan, in the course of the divorce, decided to transfer assets into a spendthrift trust for Brian's benefit. Remember, Brian needs somebody to manage funds for him. He needed a trustee. He had lost his mental capacity to handle his own finances. So as part of the divorce, the settlement involved having Susan transfer marital assets into the trust, and she transferred $4 million into the trust. Brian transferred $120,000 into the trust. He did this with assistance. This was in satisfaction of legal obligations. And what we're talking about is this was the division of assets in the divorce. So you've got $4,120,000 in this spendthrift trust. And the trust said, that spendthrift clause said that the money in there could not be used to pay judgments, that sort of thing. So he has a trustee, and somehow, even though he has mental incapacity, he was not physically incapacitated. And in 2014, some 9 years after they're divorced, he gets behind the wheel again, and he's speeding 76 miles per hour in a 35 mile per hour residential zone. He hits Shauna Calhoun head on and the child is in the car too. Brian died. He took his life in his own accident. And there was a personal injury action that was brought by Shauna on behalf of herself and her child. And here we have a trust with spendthrift protections. And the court had to deal with, are we going to give these victims some assets from the trust, or is the spendthrift provision going to be strong enough to block them from the assets within the trust. And the court held that the plaintiffs could recover from the trust. The reason they did that is because this trust was settled by Susan herself and Brian in the context of divorce. And because the funds were transferred to satisfy legal obligations in the divorce, because the trust was predicated on the divorce itself, the Spendthrift Clause didn't work. And so the bottom line, the takeaway for you here is that the trust was totally vulnerable to being attacked in connection with this personal injury suit. So although we talk about spendthrift protections, keep in mind that sometimes under certain circumstances, spendthrift clauses are not going to immunize your trust from the attack of a spouse. I'm going to turn it right back over to Tiffany so she can talk about another term, ascertainable standard, and those types of facts and how they factor into our analysis.
Thanks, Lisa. The phrase ascertainable standard does come up quite a bit when we're talking about trusts and when we're talking about how those trust interests might be allocated or divided or not incident to divorce. So what an ascertainable standard is, it's a standard for distribution. There are some trusts without an ascertainable standard that will grant essentially unlimited discretion to the trustee to make distributions to the beneficiary. When a distribution is subject to an ascertainable standard, the discretion is still quite broad, but it is limited to these particular categories of distribution, and what we often refer to as the HEMS standard, H-E-M-S. Distributions can be made for a beneficiary's health, education, maintenance, and support and reasonable comfort. What does that mean? Health is pretty easy, education, pretty easy. When we get to maintenance and support, what does that mean exactly? Well, what it requires the trustee to do is to really examine the standard of living that a beneficiary has enjoyed and what that beneficiary needs in order to maintain that standard of living. It's sort of similar to the way we analyze a divorcing spouse's need under the alimony statute. So in the same way that a divorce, a probate and family court judge might look at a recipient spouse's need based on the lifestyle enjoyed during the marriage, so too would a trustee examine a beneficiary's lifestyle and need in determining whether to make a distribution under an ascertainable standard. Still very broad discretion, but not exactly unlimited. And Lisa, for a discussion of decanting and what that means?
Sure. So decanting is a relatively new concept in Massachusetts. And when you think of decanting wine, you think of taking a decanter and pouring it so that the best part of the wine ends up in the glass and it leaves sediment behind. You're actually pouring from a decanter into a separate vehicle. And it's the same thing here. Decanting is a trust concept that allows us to pour the assets, the best part of the trust, into a separate vehicle. And what is that separate vehicle? It's a new trust. It's a trust that has provisions that you wish you had with the old one, but didn't have because you didn't see it coming. And so when you decant, you can now take your assets and put them into the trust that you would have had if you'd had the opportunity to do it the way that if you had hindsight's 20/20. But when you're drafting, you might not have the foresight at the time to know what provisions you need. So you can decant a trust and take the assets, put it into a brand new trust that has brand new trustees, or that changes the intent of the grantor, the person who established the trust. So perhaps you want the trust not to be used for health and education support and maintenance. Perhaps you want to change it and have it be used for some other purpose. Or perhaps there's unintended tax consequences the way you drafted it, and you want to have a redraft it so that you get better tax treatment. By the way, especially in a upcoming election year when we may be dealing with different tax strategies and different opportunities for gifting, now is the time to be thinking about decanting. But that's a side note. If you have questions about that, call us. We have precious little time before the election, but we're happy to help. And we anticipate that we can help up until the end of the year with certain gifting strategies in your trusts, if that's relevant for you. But in any event, in the Morse v. Kraft case, this case was decided in 2013. This was a case where the court decided that you can indeed pour assets into a new trust that is more favorable to you. And that can be a substantive change. So in this case, Morse was the sole trustee of the Kraft Family Irrevocable Trust that was created by Robert Kraft back in 1982. It was for the benefits of Robert and Myra Kraft. The class closed in 2011. What that means is that the trust said that the trust will keep, the beneficiaries will keep expanding, meaning those people entitled to receive assets from the trust will get larger and larger. The group will get larger and larger until a certain point, at which point the trust closes. That means that there's no more beneficiaries who can be added to receive benefits. So in 2011, the class closed with the birth of the fourth son. There were 4 sons, and that trust closed. At that point, the trust only allowed distributions of trust funds if it was made by a disinterested trustee. Morse decided he wanted to delegate some of the decision-making about distributions to the sons, who were not yet adults. Now, just so that you know, when you're talking about a disinterested trustee, what you're talking about is maybe you're bringing in a lawyer who's going to make the bottom line decision whether or not to distribute money. That's a disinterested person. Or you bring in a friend or somebody who's not a family member, not a beneficiary, not an heir, not anybody who's really truly connected to the family by blood or marriage or by kinship. You're bringing somebody totally disinterested in the eyes of the law, non-familial. And so what Morse wanted to do is delegate the distribution decisions to the sons themselves, to family, rather than a disinterested trustee. And so he had the assets pour from the old trust into the new trust. And the court stated that the intent of the grantor, the intent of the party who created this trust, is paramount in determining whether or not you can decant. And that forces everybody in court to start looking at intent. Suffice it to say that you can make significant changes to a trust by decanting, and the courts sometimes will allow it and sometimes not. It's something that you want to do with the benefit of counsel. Don't try this at home. This is not a do-it-yourself trick. This is something that really requires a lot of strategizing between divorce counsel and trust counsel. It's a high caliber move. It's a strategic, sophisticated move. But if you're in a position where you're trying to protect significant assets, as the Crafts were back in 2013, there's an opportunity here for you. There's a strategy. The takeaway really is that there is power to amend a otherwise unamendable trust. But the question remains whether a court will let you do that if amending the trust might impact alimony rights of the spouse, or might impact child support, or might impact the division of assets. So these are all factors that the court will consider. With that, I'm going to turn it right back to Tiffany so that she can discuss really the cast of characters. Who are the beneficiaries? More information about opening and closing of classes, trustee, independent trustee, trust protector. Take it away, Tiffany.
Thanks, Lisa. So a lot of these terms we have brought up already in our discussion, but before we move on to talking about the divorce case law and the treatment of trust interest in divorce case law in Massachusetts, I do just want to review the cast of characters briefly so that we all know who we're talking about when we use these terms. So first we have the grantor or settlor or donor. Those terms are all used fairly interchangeably, and that is the person who is creating the trust, who is transferring property into a trust then to be held for beneficiaries. Beneficiaries are the people who hold beneficial interests in the trust, and these can be lifetime interests. They can be people who are eligible to receive distributions of income or principal during their lifetimes, or they can be remainder beneficial interests. So there can be beneficiaries whose ability to receive income or principal will happen only upon the death of the lifetime beneficiary. Those classes of beneficiaries can be open or closed, as Lisa was just discussing. So one category of beneficiaries in particular, grantors sometimes leave their trust interests to their descendants or their issue, which is a fancy way of saying their children and grandchildren. So for so long as people continue to have children, either biologically or through adoption, that class of beneficiaries can continue to grow. So there may be 2 children and no grandchildren born at the time that a grantor establishes a trust, but by the time the grantor dies and the trust becomes irrevocable, there could be additional children and grandchildren and even great-grandchildren. So that class remains open until all lives and beings cease adding to the class. The person in charge of administering the trust is the trustee. That's the person who has fiduciary duties to the beneficiary, as well as duties to the grantor, in order making sure that the intent of the trust is carried out for the benefit of the beneficiaries. The grantor himself or herself can be a trustee. A beneficiary can be a trustee. There can be more than one trustee, and there can also be independent trustees who are sometimes family members who do not have beneficial interests, sometimes professionals, lawyers, accountants, financial advisors who agree to take that role and help administer the trust and make distribution decisions. Another person in the cast of characters, or a potential person, is one that is coming up more and more frequently these days. It's called a trust protector. So a trust protector is an individual that I've seen most frequently in irrevocable trusts, a person who is named to ensure that, notwithstanding that a trust might be irrevocable, meaning that the person who established it cannot change it, the trustee cannot change it, there may be this trust protector out there to make sure that changes can be made down the road if they need to be, if there are changes in the law or changes in other circumstance, really to just make sure that the settlor's initial purpose can still be carried out and not be frustrated by changes in the law or changes in factual circumstances. The trust protector cannot be the settlor or grantor. The trust protector cannot be a beneficiary, and the trust protector cannot be a trustee. It has to be somebody who is out there, independent at a higher level, and most frequently I would see this as a role for an attorney to play. So having defined all of the potential cast of characters and having talked about some of the other phrases and catchphrases here in trust law, I think we are now ready to dig into some of the case law. And so for some of the earlier case law on trust, interest, and divorce, I am handing the reins back to Lisa.
Thank you, Tiffany. So yes, I'll discuss the older case law, and then Tiffany will bring you right up to present with the present and current case law, which, by the way, is evolving all the time with new decisions every month. So we'll just discuss the main ones. There was a case back in 2004. It's called DL versus GL. This was a case involving stewardship, trusts that were there for stewardship. So sometimes when families establish family trusts, they don't intend to have it be used up right away. They intend for the funds to be there for generations after generations. And in this particular divorce, DL versus GL, yes, these involved family trusts that had significant value. There were 7 trusts in all, and they had a value of about $100 million. The question in this divorce is, are they up for grabs? And the court ultimately said, no, they're not. But listen to this, the parties were married in 1986. They separated in 1996. So this was a 10-year marriage. It wasn't nothing. And the parties were in their 40s, their mid-40s. They were both well educated. They were both in good health. They lived a very nice life. They lived in an 8-bedroom, 8-bathroom home. The wife also had substantial means, even though these trusts, the 7 trusts, were on the husband's family side. The wife also had significant assets as well. They had a very traditional marriage where she stayed home and took care of the home, and he went out and worked. They lived an affluent lifestyle. And ultimately, the judge, hearing this divorce, excluded all 7 trusts from division. Now, you know, I said initially that any assets that you come to the marriage with, if you don't have a prenup, are up for grabs. In this case, the court said none of those 7 trusts are up for grabs. So why? So there's some reasons here. And this is where Tiffany and I are looking at the trending in cases through the years. This is why we discuss this stuff, is because the courts keep developing new rationales. And this is how we determine how we're going to advise you. In this situation, these family trusts were called, they were stewardship type trusts. They were there for 38 years. And for 38 years, not one payment had been made to the husband. The couple had not lived on a dime from those trusts. Yes, they had other assets from the families that they lived on, but not once did they spend a dime of money from those trusts. In addition, the trust assets, there were some discretionary standards in how the trusts could be used. It was so discretionary, and these assets were so far away from the marriage in the way that they were maintained that the couple didn't really even know the true value or the different standards for distribution. They were just kind of ignored through the marriage. They were there, everybody knew they exist, but they weren't used, they weren't tapped. And so the court decided, you know, these assets have not been woven into the fabric, just like Tiffany was discussing. When you weave into the fabric of the marriage the assets from a trust, those trusts become vulnerable. But in this situation, they had not been. And so the trusts were excluded. There was another case, Laricella versus Laricella. This is back in 1991, where the husband came into a marriage with real estate. His father had created a trust to hold a 2-family home in Newton back in 1976. And he had 2 kids, a son and a daughter. Well, his son gets married. His son, Joe, marries Dawn. And they live in one of the homes in the 2-family home. And they end up getting divorced. And the wife says to the court, this is our only asset. And this is very typical of families. Very often families have just their marital home. And she says, this is our only asset. I need it. I'm raising the boys and I have the kids, and I need for the kids and I to stay in this house. I need to keep this portion of the trust as part of my marital distribution. The court decided in this case, yes, the trust is up for grabs. The court looked at many different factors and felt that because the husband's right to the trust was present, meaning because it was not remote and something that would be distributed at some indefinite point in the future, but because they were using the trust assets during the marriage completely and dependent on it, that yes, it was a present, enforceable right to use the property for the benefit of the family right now. They exercised that right. They were dwelling in it. He could use it for rent. He could have kept it to live there, but instead the marriage ended and the trust was up for grabs. So that's how that one was dealt with. There was another one of my favorite cases, Donna Williams versus Donald Massa. The reason I love this is because I always found in law school that the courts would try to do the right thing, even if there wasn't necessarily the right law. If the facts were right, the court tried to do the right thing. If the law is right, the courts try to do the right thing. Sometimes the law and the facts are not with you, and you just have to bang your fist on the table and do what you can. But the Williams versus Massa case was one where the court did the right thing based on compelling facts. So in this case, this is a 2000 case. Donna and Donald were getting divorced. Donna was an artist who stayed at home. Donald was a CEO. And there were about $1.9 million in gifted assets. There was about $2.3 million in inherited assets. This was a marriage where Donald worked very hard and contributed very much to the marriage. He was a CEO of a company for 25 years. He did it all. He worked hard, brought money into the family. He used to make the family's meals. He would come home from work. He's a CEO. He'd come home from work, make lunch for the family and for his wife. He would set the table. He would cook. He cleaned. He made dinner. He did the household chores, and he also worked. And Donna was an artist who did not contribute to the household. She was very often doing her own thing. And when the relationship fell apart, she started to alienate the relations between Donald and their children. So she literally alienated the daughter's relationship and started to take steps to do the same with the son. After all of this, the court took a look at these assets. And the question was, are these gifted and inherited assets and trust assets up for grabs? And the court said, nope, they're not, and protected the money with Donald. In this situation, the court used as a rationale that the husband had always managed these assets and had separated the asset, hadn't necessarily separated the income, but did separate the assets, and the income was used for child support. So the court did the right thing there too. So because the income had been used in the marriage, the income from these assets, the gifted, inherited, and trust assets, were used for child support for the children. But these gifted and inherited assets predated the marriage. And even though I told you early on and that, the statute says that even assets that predate the marriage could be up for grabs, in this case, the court said no. There were, and I'll quote, there were substantial and fundamental mental failures by the wife throughout the marital partnership, is what the judge said, and therefore allowed the husband to keep those trust assets, gifted assets, and inherited assets for himself. And this is where conduct of the parties and contribution weighs in. I want to be mindful of the time and let you know of one other case. And then we're going to turn it back to Tiffany to bring you right up to date, because I'm going way back into history. I'm getting closer. I'm now at 2016, and I'm going to discuss the Vandenshiel case. So this is a case where the parties were married in the year 2000. Their father, Kurt Phantomshields' father, in 2004 created an irrevocable trust that did have spendthrift protections. It said it couldn't be alienated in divorce, meaning the assets of the trust couldn't be divided up and used in lawsuits to satisfy a judgment, including divorce. And despite that spendthrift clause, this still came into court with the question of whether or not the assets could be chopped up in connection with the divorce. So I just want to tell a little bit about the history here. So Kurt Vandenshiel was one of many children of the grantor of the trust. And at the time of the divorce, there were 11 beneficiaries of the trust. He was not alone. And the class was still open, so it had not yet closed. There was a chance that there'd be more beneficiaries. The trust said that there was no obligation to equalize distributions between people. Ultimately, the couple lived a comfortable lifestyle in the Wellesley area. He worked at a bookstore. She was taking care of their two children, both of whom had some special needs. And the court took a look at this trust. And also noted, I should mention, that the family had lived on trust distributions for a good long time. In fact, they had lived on distributions that in one particular year had reached the $350,000 level of distributions, multiple sequential distributions, but altogether had lived on about $350,000 worth of distributions. The trustees would make distributions as needed. And at the 11th hour, right before the divorce, they stopped making distributions. This went in the lower court to a judge who took a look at the situation and decided that the fact that the distributions had stopped at the 11th hour before the divorce was a problem for her, for the judge. It was a problem for her. And she awarded Diane with 60% of the trust asset and the rest, or of Kurt's portion, 60% of Kurt's portion. And that went up on appeal. And I will tell you that it was a significant case on appeal. There were many factors that related to the fact that the law was not followed. The facts, the judge had very much been led by the facts in this one that had a real hit your gut kind of feel, but the law hadn't been followed. And the case went up on appeal, and the appeals court reversed it and said that the class of beneficiaries was still open. The interests were too remote. The court really could not really divide this up. The court also said that Kurt never had the ability to compel distributions. This wasn't really his doing. So ultimately, the court said the interest in the trust is too speculative. The interests are remote. There's no requirement to equalize. And so the court reversed itself and looked after Kurt the second time around. And with that, I'm going to turn it over to Tiffany, who's going to bring us up to date and who may have other facts to share about Vandenshiel based on her extraordinary experience with it.
I do want to chat about the Vandenshiel case just a little bit more because I had the opportunity to work on that case directly. Our partner, Bob O'Regan, came into the case after the trial court had made its decision as it headed to the appeals court. And it was actually the appeals court actually did affirm the trial court in a divided panel, but the majority opinion did affirm the trial court, really based on its sympathies for the wife, the same way that the trial judge had been trying to do the right thing because of the sympathetic facts of the case. When we sought further appellate review at the SJC, that's when things were reversed. And that's when the case was remanded back down to the trial court, and I was a part of that team as well, the remand team, to figure out what to do with the assets here, given that the SJC ruled this particular trust interest was too speculative and remote to be divided the way the trial judge had divided it. And just to be clear on what the trial judge had done, she had taken the value of the trust portfolio as of the date of divorce, which was about $24 million, and she divided it by 11 because that's how many beneficiaries there were at that time. So she took the 24 million, divided it by 11, notwithstanding that additional beneficiaries could be born into the class, and she awarded Diane Vandenshiel, the wife, 60% of Kurt Vandenshiel's 1/11th share of the $24 million, and ordered him to pay it in equal installments over the subsequent 24 months. Now, Kurt couldn't do that because Kurt didn't have that kind of money to make those payments outside of the trust, and he had no power to compel the trustees to distribute assets to him to make those payments. So he wound up being held in contempt of court for failure to make those payments. And so the case was a whole storied mess. Ultimately, the SJC did overturn the trial court, but was very careful to note that in ruling that Kurt's interest in his father's trust was not part of the marital estate that could be awarded to Diane Vandenshiel, that did not mean that the consideration of the trust was entirely off the table in other respects. So for example, as I indicated earlier on in this webinar, any distributions that Kurt would receive from the trust in the future could be taken into account for support purposes. Kurt's future expectancy in this trust could be considered when dividing what else remained in the marital estate, although the marital estate outside of this trust was fairly modest. But in other situations, one spouse's trust interest outside of the marital estate could warrant a disproportionate division of what else remains for the non-beneficiary spouse post-divorce. So just because the trust asset itself can't be divided doesn't mean it can't be taken into account in other ways. And that's really what the SJC directed the trial court to do on remand. When we got back down to the trial court level, it was a different judge. There had been judges moving around from county to county, and we did have to make these different arguments about what could and couldn't be done on remand, and ultimately were able to resolve the case. But it was a very interesting case. It garnered nationwide attention, really. I had phone calls coming from, I went to law school out in Colorado, and I had former classmates of mine calling me up and saying, what is this Vandenshiel case? And by the way, how do you pronounce that and how do you spell that? And what are you guys doing out there in Massachusetts with these trust interests? Especially when the appeals court had affirmed the trial court, there was just uproar and pandemonium all over the place. So very, very interesting stuff happening here in Massachusetts. And just very briefly, I'll touch on two cases that have been decided since Vandenshiel. We are running up right against the end of our time here, but just very briefly, in 2019, the Leviton case was decided, and it came out different than the Vandenshiel case, where the wife's trust interest in the Leviton case was considered part of the marital estate subject to equitable division. The distinguishing factors there was that the wife's trust interest in Leviton was just her share trust. So when her father had died, the trust was divided into 3 shares, one for her and then others for her siblings. So it was just her share of the trust that was being considered here. There was an independent trustee, so the wife didn't have full control over what was distributed or not to her, but she did have significant withdrawal rights. So she had the right to demand a certain amount of income and principal be distributed out to her each year. She also had a limited power of appointment to direct what would happen with the remaining assets upon her death. So under those facts, the court did hold that the trust interest was part of the marital estate, but because there was a spendthrift clause in that trust as well, it was only assignable to her. So the trial court could not assign part of wife's trust interest to the husband. It would be part of wife's share of the ultimate asset division, but it was part of the marital estate. So he would get other assets to offset it. Then most recently, in fact, just a few months ago in 2020, the Savoy case was decided. And again, in the Savoy case, the wife's trust interest was held to be part of the marital estate subject to the equitable distribution statute. What's interesting there is that there was an open class of beneficiaries, and there were additional beneficiaries other than the wife with respect to the trust interest at play here. But the wife herself was a trustee, and she had what the court described as unrestrained discretion to make distributions. And in fact, she had made substantial distributions to herself. So those were facts that were really compelling to the court in deciding that that particular trust interest was within the marital estate subject to equitable distribution. So with that bringing us up to date on the case law, although I did have to kind of hurry through those last 2 cases, and I apologize for that. If anybody has questions or wants further discussion, please feel free to reach out. And Lisa, I will let you wrap things up here.
Sure, I'm happy to. And that was a great explanation of the recent case law. It's still changing. There's cases being decided every month. So keep in touch with us if you need to reach us. And before we go, we're going to give you our email addresses and phone numbers so that you can reach us. But suffice it to say that there have been a lot of trends. The court has flip-flopped a little bit. There have been times that the court has ruled in favor of chopping up a trust, and times when the court has left a trust intact. Some trusts are vulnerable and others are not. And if you need advice about how to protect your family assets and your trusts, let us know. We will both tell you that one of the best ways to protect your assets is by thinking about prenuptial and postnuptial planning. Burns and Levinson has had other webinars like this by our colleagues that have discussed prenuptial and postnuptial planning. So if you want to watch those have been recorded, and we would be delighted to share those with you. Or if you want to call us or reach out to us by email, we're happy to share information. So Tiffany, why don't you start with your email address and phone number, and then I'll finish up with mine.
Sure. My direct dial is 617-345-3212. And my email address is tbentley, that's Bentley, like the car or the college, at burnslev.com, BURNSLEV.com.
Thanks. And my phone number is 617-345-3471. that forwards directly to my cell, so you'll catch me at any time. And my email address is lcukier@burnsleve.com. That is spelled LCUKIER at B as in boy, URN as in Nancy, S as in Sam, LEV as in victory.com. It has been our pleasure to do this webinar for you. As you can probably tell, we love handling these matters, both on the trust litigation side and on the divorce side, as well as giving consideration to estate planning and prenuptial planning. If you need us, we're always here for you. Thank you.
Thanks, everybody.